Hi, guys. Today, can you hear me? I hope everyone can hear me. It's Christine here from the Canadian Constitution Foundation. I'm just back at my hotel now. The hearings have finally wrapped up for today in the Public Order Emergency Inquiry or Commission. These are the public hearings looking into the federal government's decision to invoke the Emergencies Act for the first time ever in response to the 2022 Freedom Convoy. I'm the litigation director with the Canadian Constitution Foundation. I'm in Ottawa all week attending these hearings in person to watch in person. And my organization, the Canadian Constitution Foundation, is actually a party in this inquiry. So we are participating, we're cross examining witnesses. We cross examined both witnesses today. Today was Public Safety Minister Marco Mendicino and Intergovernmental Affairs Minister Dominic LeBlanc. I have not posted the the um, the summaries of those cross examinations yet. I can see the comments. Michael C. Miller did get back in. I'm going to tell you guys all about what happened with Miller. Uh, I was there in person. I saw everything. I have the full context and the full story, so I'm going to tell you all about it. And let me get started. Yes, it is a very long day for me. So, okay, this video is actually just going to be a summary of Minister Mendocino's evidence. And that's because that's more what I'm interested in. That's what's more relevant for us. But also because the Minister LeBlanc literally just finished testifying. And I came back to my hotel to record this video right away. I have not had a chance to write down all my notes and go through all my notes about Minister LeBlanc. So this is just going to be about Minister Mendocino and about what happened with Brendan Miller. I know you're probably all interested in what happened with Miller, which he's the lawyer for the convoy. I'm going to get to that. But first, let me tell you a little bit about what happened with Minister Mendocino. So, because there's a bunch of backstory that you need to know as well. If you want to understand the Miller stuff, you need to understand this first. So, first, Mendocino started his examination in chief with Commission Counsel with a bit about his background, which I will be honest about. I was not super familiar with Minister Mendocino's background. He's a former Crown prosecutor, and then he worked in the private sector as a lawyer for a number of years. So once I had heard that, I realized he was probably going to be a pretty slick witness, given that he has a lot of experience conducting cross examination. So he would probably know how to appear in a cross examination, and he would have prepared many witnesses for cross examination. So I was right. He was very prepared. He was pretty Teflon, a challenging witness. But let me tell you a few things that really stood out to me. First, one thing he said at the beginning was, in his opinion, the convoy, what he called the manifesto, which I think he means this MOU document that we've heard a little bit about. He said, in his opinion, that was the spark for the convoy. Now, that's his opinion. And actually, I do not think that that is supported by the evidence. We've heard from a lot of protesters, including protesters who testified at this inquiry, that not only were they unaware of the MOU or they found out about it quite late, many of them didn't agree with this MOU document. So I do not agree with the minister's remarks there. Another thing Minister Mendocino said at the beginning was he said there was potential for violence in the protests from the outset and cited one protester named Pat King. We've heard Mr. King's testimony, we've heard a lot about him, including some of his objectionable views. Again, I do not think that there's evidence to support that there was potential for violence from the outset. Indeed, we heard from a number of policing witnesses that the protests were actually notable for their absence of violence. I guess if we want to give Minister Mendocino the benefit of the doubt, we could say there's potential for violence, but that would be true of basically any human activity and every single protest. So I do not think I agree with that statement either by Minister Mendocino. Minister Mendocino also talked about security issues in Ottawa. After all, he's the Minister of Public Safety. And he testified that security services were provided to cabinet ministers and there was a heightened security posture at Parliament. He said Parliament continued to sit because it was important, he said, for Canadians to see the business of government continuing. And he testified that this heightened security was because of intelligence from security services based on information from social media and because of complaints to his office that his office had received. And he gave an example. Minister LeBlanc had told him that MPs were worried about protests at their homes. Minister Mendicino was then asked about a text exchange that he had with his chief of staff, an individual named Mike Jones. And in that text, he said, to quote, "We may need to look at other measures." Now, Minister Mendocino said by that, he meant how to get more boots on the ground in Ottawa. And he said for that to happen, the OPP had to be the first stop based on the Police Services Act. Now, my opinion here, that is not really true. And we cross-examined Minister Blair about this yesterday, where we put to him that the Police Services Act permits local police to seek assistance from the OPP, but it doesn't actually require them to go to the OPP alone or first. They could go to other local police forces, they could go to the RCMP first, or even simultaneously. And yesterday, when we put this to Minister Blair, he agreed with this. And not to skip ahead, but we also cross-examined Minister Mendocino about this. So it's quite good that we've nailed them down that while conventionally, the local police may start with the OPP, this actually isn't required, and that the Ottawa police had the option to go to the RCMP. And again, this matters. It matters a lot, actually, because the Emergencies Act is a tool of last resort and other options need to be exhausted. So if there was this option to go to the RCMP from the outset, the Emergencies Act was not actually required. They had not exhausted all of their options. Now, before talking about our cross-examination, let me finish going through the other things that Minister Mendocino said in his examination in chief. There were a number of discussions related to these tripartite meetings between the federal, provincial, and Ottawa municipal governments. Minister Mendocino, we heard a lot about this yesterday as well, but Minister Mendocino asked if he agreed with Ottawa Mayor Watson's characterization that the province was, to quote, reluctant to join those meetings. And Minister Mendocino testified there was desire for Ontario Solicitor General Sylvia Jones to be there, but that they were still able to have conversations with Ontario through officials. He was then shown a text exchange between his chief of staff, Mike Jones, and Bill Blair's chief of staff, Zita Estravas, where Estravas said she thought Mendocino should call Sylvia Jones, the Ontario Solicitor General, to get her to the tripartite table. Jones said that the last call to her hadn't gone well. He said it was, quote, frosty at the end, and that Sylvia Jones had told Mendocino to, quote, "I don't take edicts from you. You're not my fucking boss." Excuse the language, but that was what was read out today. Minister Mendocino said, yes, this did happen. It was a very stressful time for everyone, that we've all heard this kind of what he called blunt language before, and that, in fact, he really does have quite a collegial relationship with Sylvia Jones, I guess, even if these text messages don't reflect that at that time. To me, the whole, the feds can't tell me what to do is obviously funny because it's funny language, but it's also what our federal executive director, my boss, Joanna, has jokingly called federalism in action, which I think is objectively hilarious if you're into federalism jokes. So Mendocino also spent some time talking about concerns that we've heard before raised by Minister Blair that Sylvia Jones didn't want to participate in the tripartite table because of this concern that politicians should not get involved in policing operations. Now, at the inquiry, this is being referred to colloquially as the church and state separation. So if you hear that term during the inquiry, that's what they're talking about. This notion that the political level cannot give operational direction to police. Now, Minister Mendocino testified that there are important boundaries and the government doesn't want to interfere with law enforcement or with prosecutorial discretion, and that his government abides by this boundary at all times, but there should be dialogue with police. Now, When Minister Mendocino said that his government abides by this boundary at all times and never interferes with prosecutorial discretion, all I could think of was Jody Wilson-Raybould, and that she might have something to say about that and whether that's true or not. Minister Mendocino was also asked about Ottawa Police Chief Slowly, his concern that the public call for 1,800 officers resulted in the Windsor blockade and in calls for more protesters to come to Ottawa in order to outnumber the police. Minister Mendocino replied that he had concerns about that, especially because he said there were two groups of protesters, one group of regular folks, and then a group, mostly he said at Coventry Road, who had a background in military and law enforcement and who could use what he called counter tactics. So he said because of that, disclosing policing numbers is not a good idea. It was then time for the morning break. And now this is the moment I think a lot of you have been waiting for me to talk about. This is the big drama with Brendan Miller. He's the counsel for the Convoy organizers. This is where all the crazy stuff started to happen. I think by now, probably a lot of you watching this will know that Mr. Miller, the Convoy's counsel, was ejected from the hearing today for a period of time. So I'm going to try and explain exactly what happened. I'll start by telling you that what I saw exactly in the room this morning before it all went down. When Minister Mendocino came in, he sat in the chair directly, right in front of me, and his staff sat beside him. So some of his staff were pretty junior. They looked like they were about in their 20s. And is sitting across the aisle from me, just, on the, there's a little aisle we can all walk down. On the other side, directly across from me, is where the protesters were sitting. And they at one point in the morning during Minister Mendocino's testimony, one of the protesters came over and sat beside Minister Mendocino's staff. So he was up testifying. Protester came down and sat beside staff member, Mendocino's staff member. And she introduced herself to a young man on Minister Mendocino's staff. And he introduced himself to her as the director of communications. Now, I noticed this. I thought, oh, that's a little odd. I've been attending in person for a day and a half. I did not think that these two groups of people would care to introduce themselves to each other. But, the protesters, they seem like pretty friendly people. I've talked to some of them, and all of the counsel at the inquiry are very collegial to each other. So I was thinking, oh, maybe this is just what people are doing here. We're building bridges. People are being nice. Well, what was really happening was I think that the convoy organizers had recognized this young man. His name is Alex Cohen, because when Mr. Miller, the convoy counsel, stood up right before that morning break, he asked Justice Rouleau to rule on an oral motion he was bringing right then and there to call Alex Cohen, this young man sitting in front of me, as a witness. He said, Alex Cohen is here right now, and he should come up to testify. So, little explanation for the reason Mr. Miller was asking for this. We have been receiving, the parties to the inquiry have been receiving large dumps of documents from the government quite late. We got some yesterday, and we're getting tons of them constantly. And it is not good. It is not very fair to the parties. And the documents also have a lot of redactions, which may or may not be proper redactions. Mr. Miller, the convoy counsel, brought a motion last week challenging some of those redactions as improper. And he argued that the redactions were improper because they were redacting conversations between Minister Mendocino and his staff, the staff that were sitting in the room right in front of me. And the government was claiming cabinet confidence or parliamentary privilege over these conversations with staff. And obviously, a conversation with staff would not qualify for cabinet privilege, cabinet confidence. We actually, at that point, did not have a ruling on this motion about these redactions. So Miller was trying to get around that and get to the heart of those redactions by calling one of the staff directly as a witness to ask what was underneath those redactions. So this wasn't really explained until later when convoy counsel Keith Wilson, the other convoy lawyer, explained what had happened. So Miller gets up right before their morning break And he asks that Alex Cohen, sitting right in front of me, be required to testify. This young man in his 20s, probably there staffing his boss, not expecting this to happen. So Rouleau says he's not going to hear motions orally like this. So Mr. Miller asks him to decide after the morning break. Let us know when he comes back. So we take the break. Alex puts his coat on and runs out the door. This was obviously, I would assume, a huge shock to him. So then we come back. Alex is gone, and Miller is up at the podium, and he asks about this motion to compel Alex to testify, even though Alex is at that point gone. It got really heated. And if you haven't seen the video, watch it because I'm not going to do it justice. But Rouleau says he's not going to hear a motion orally like this. It has to be in writing. Miller keeps interjecting and interrupting, and Rouleau tells him to stop interrupting. Miller keeps interrupting, and Rouleau says we're taking 5-minute break so Miller can be removed. Miller goes back to his desk. Security is just kind of standing there. I can actually hear security talking as they're standing around me, saying they need to confirm if they actually have to remove Miller because they don't really know what's going on either. Then security comes back. They go up to Miller and they escort him out. And my understanding is that Miller goes outside and he does some interviews with media. So a few of my thoughts. Um, sorry, excuse my cough. Miller has been pretty effective on some of his cross examinations, and I also think he has come across in a lot of his appearances as a pretty likable guy. But continuing to interrupt a judge is not professional, is not appropriate, and is not effective, is not good for your clients. There are all kinds of ways that Miller could have raised his concerns about these privilege claims, which in fact the Convoy's other lawyer, Keith Wilson, did raise after the morning break. And Rouleau said when those were raised, he said, if it had been raised like this, I would have dealt with it in a different way. And Rouleau did say when Keith Wilson brought this up, he said he would provide a ruling on those privilege claims right after lunch, which he did. And in fact, some of them, the claims over staff communication in particular, ended up having those redactions removed. So this whole big drama was unnecessary and actually did a bunch of damage. So that's what happened. I hope you like hearing all of this background stuff because it was pretty interesting to watch. Very crazy day. So then we got back into the normal questioning. Miller's gone at this point. We don't know if he's going to be allowed back in. So now commission counsel is up and they continue their line of questioning. Minister Mendicino is asked to explain why he believed the threshold to invoke the Emergencies Act was met in light of what he testified was a reluctance to use it. And Mendicino testified that reluctance is the right instinct to have given the law's history since it was enacted to replace the War Measures Act. He said the Emergencies Act consciously doesn't reference the military, but it does give the government broad powers, and it's not to be used for anything except for the most serious circumstances. This is what Mendicino said. He was also asked explicitly then about the threshold in the Emergencies Act and its reference to the CSIS Act definition of national security threat. Now, remember, the Emergencies Act defines national security threat with reference to the CSIS Act, and CSIS said under its legislation, there was no national security threat. So how was it then that it was met for the Emergencies Act? I mean, this is the big question we all want to know the answer to. Now, Mendocino said CSIS assesses national security threats through their mandate and functions, and that the situation with the protest was very different. It's not like how CSIS uses their act, for example, to obtain a warrant or a wiretap, things like that. He said this is about protests that had become illegal across Canada. So Mendocino said the government looked at the broader purpose of the Emergencies Act, he said, drawing on his understanding of the law and the facts on the ground. Now, my opinion is that this is no explanation at all. This belief that the government can simply broaden the meaning of the legislation and imagine words that aren't there is completely wrong in law. And I really hope that this is something that the commission refuses to accept because it's not justifiable in any way. Mendocino was also asked about this email we've heard a lot about that Brenda Lucky from the RCMP sent to him and to his chief of staff saying that all legal tools had not been exhausted. Again, this is important because the Emergencies Act is a tool of last resort. Mendocino says he doesn't recall this email, which I think is pretty odd. And frankly, I'm skeptical. And he also says that Lucky never expressed this to him directly. So I think on that issue, Lucky looks pretty bad. Mendocino looks pretty bad. His chief of staff looked pretty bad. This is obviously very important to whether or not the Emergencies Act can legally be invoked. And they've all kind of just swept this information under the rug. So then we get to cross-examinations. The convoy was supposed to be up first, but since Brendan Miller had been ejected, Keith Wilson, their other lawyer, said he was not prepared to proceed because we was not expecting this to happen. Rouleau said at that point he was not going to let Miller back in. No one asked for Miller to be let back in at that point. And he said since Convoy has co-counsel, they would need to coordinate. I think you all probably know at this point that later on in the afternoon, Miller was allowed back in and he apologized for interrupting Commissioner Rouleau, and he was able to proceed with a cross-examination. Unfortunately, in my opinion, a bunch of time in that cross-examination was spent wasted. It was used on questions related to this false flag theory that came up yesterday. This is the allegation by Miller that a government relations person, who I won't name, who's connected to the Liberal Party, had been the one to carry this Nazi flag at the protest, I guess, ostensibly to make the protesters look bad. And that CSIS knew who this person was. And I don't know if that is an accurate reflection of CSIS's evidence either. So Miller asked Mendocino if he knew that man's identity, and Mendocino said he didn't. And he didn't really even seem to know where any of this was coming from, because remember, Mendocino said he did not watch any of the testimony from yesterday where this false flag theory came up. Now, I'm going to tell you why I do not think this is a good use of time. First, it is not a convincing argument. Second, this commission has way bigger fish to fry, and this issue is not relevant to the core mandate of the inquiry. The inquiry should focus on things like why cabinet wasn't briefed on key information and why the government is making up new words in legislation that aren't there, and why different levels of police failed to coordinate and use existing legal tools. It is not really relevant who carried the swastika flag, which is obviously abhorrent, but it's actually not really relevant to the question we're all at this inquiry to answer. Finally, even if this false flag theory is true, which I'm pretty unconvinced of at this point, the people Miller is questioning about it actually have no knowledge about it. So even if it's true, it is not a good use of his time to ask these individuals about it. There are so many better questions that Miller could have asked. He did end up asking some questions that I did think were good related to the definition of the Emergencies Act, but that was at the tail end of his cross-examination. So in my opinion, this was badly wasted time. And the government of Canada actually objected to the line of questioning related to the false flag theory, saying it was an abusive process and not related to the purpose of the inquiry. And he said they're not good faith questions because the witnesses can't even answer them. And on that last point, I would agree. Rouleau said that he would when the government of Canada objected, Rouleau said he would let Miller ask the questions since there's an outstanding motion to bring a witness who Miller says has evidence about the identity of this flag carrier. And Rouleau has yet to rule on that motion. So Rouleau said he can ask these questions, but I can tell you, being there in that room, Rouleau did not seem impressed about this line of questioning. And if the judge that you're presenting in front of is not interested in the arguments you are making, as a lawyer, you should move on to something else that the judge will find convincing. Otherwise, you're just wasting everybody's time and your client's resources. So now let's turn to some of the other cross-examinations. There was a cross-examination by the OPP who asked Mendocino about a text exchange between him, Mendocino, and his chief of staff, Mike Jones, where they were planning to do a trip to Windsor when the bridge reopened, to reopen the bridge and walk around. They called it an important visual to reassure Canadians. Mendocino denied that this was a photo op. This is, to me, classic politicians are going to politician. But ultimately, Mendocino did not do it because internal texts from the OPP showed the OPP thought this was a terrible visual. They called it a photo op, and they talked about trying to find any way to get Mendocino to stop it. The RCMP also advised Mendocino that the bridge photo op and the politicization of the operation, when things were still very volatile, was not a good idea. And Mendocino said ultimately he took that advice, and that's why they didn't do it. We at the Canadian Constitution Foundation also did a cross examination of Mendocino, which I mentioned a little bit about earlier. I won't go into it too much because I'm going to post the full clip of that cross examination later this evening. And I think you guys should probably watch it because our counsel's excellent and he did an amazing job. The theme of our cross examination was about existing legal tools and how the RCMP has a common law policing power that could have been used. The RCMP could have helped Ottawa, the Ottawa police. And, while there are conventions around jurisdiction, they are merely conventions, and a lot more could have been done by the RCMP. The RCMP could have been engaged earlier and engaged properly, or even right before February 13th or 14th, right before the Emergencies Act was invoked, and its use then was completely unnecessary. There was also a cross-examination by counsel for the Windsor protesters that involved a lot of questions about the safety and effectiveness of the COVID vaccine and about childhood vaccination, which again, this was related to the protest. People can have all kinds of opinions about it, but it is not related to this inquiry. We're not looking into the justification for the protests. So I think the reason counsel was raising it was he was asking if the minister had suggested a review of vaccines, maybe that would have satisfied the protesters, and then the Emergencies Act would have been unnecessary. I think it's a little bit tenuous. Fine, raise it, but it did open the door for the government of Canada to ask a number of questions related to what the government of Canada called anti-vax conspiracy theories. And I just think that opening that door is not a good idea. Anyway, the Minister Mendicino said these questions from the Windsor protest organizers should be directed to the Minister of Health. And all of this, I think, the government of Canada's examination on it, the Windsor protester examination on vaccine issues, not a good use of the inquiry's time. I did think the Canadian Civil Liberties Association had a really good cross-examination that was fruitful and relevant. They asked questions. Kara Zwiebel asked questions about those regulations that were enacted under the Emergencies Act, restricting gatherings and assembly. She asked about a strike context. We have all this conversation about strikes recently on Ontario. And she asked, under those regulations, once there were restrictions on assemblies that had the potential to disturb the peace, wouldn't those also have fallen under those regulations? So theoretically, a strike could also fall under that regulation and then be subject to enforcement under the Emergencies Act. Mendocino said that this was just about the Freedom Convoy, even though the regs obviously don't say that. He said the right to protest is preserved as long as it won't give rise to violence. So you need to read the regulation in conjunction with the Emergencies Act. I mean, I'm not convinced, since most protests carry with it some risk of violence or disruption. And also because Kara pushed back on this notion that the regs from the Emergencies Act could be read in conjunction with the broad understanding of the Emergencies Act, as Mendocino suggested, since law enforcement and the public would only be looking at the reg. They would not be looking at the broad Emergencies Act and having these wide-ranging interpretations. But Mendocino disagreed. He said the government relies on law enforcement to apply the law properly. Kara also, from the CCLA, also raised her concern that the reg isn't geographically limited in any way and that it applies everywhere, not just in the convoy areas. Mendocino, again, didn't agree that this was a concern, since he said borders are very clearly limited. But this is not an answer to that question. since the reg very clearly is not limited to borders, and the regulations applied here in Ottawa and were used here in Ottawa. There was no geographic limitation. So that was about what happened. There are a few other things. And of course, there was the testimony of Minister LeBlanc, who we also cross-examined. I'm going to put a video up of that as well. Tomorrow, we have some more cabinet ministers. We have Lametti and Minister Anand. And I just love attending in person, even if the government issued coffee is really disgusting, because I see all kinds of interesting things behind the scenes that I did not see when I was watching online. So I can't wait to fill you guys in on what happens tomorrow. Let me just check how these comments are going. Thanks very much, guys. Your comments are all really nice. Yeah, I also can't wait for the Prime Minister to be cross-examined. That's going to be happening on Friday. So you'd think our tax dollars would buy decent coffee. I'm usually bringing my own coffee. They do have government issued coffee that is just terrible. Today I needed a lot of coffee because I've been sick, as I think I told you guys. And I took cold medication when I got there this morning, and I realized within 20 minutes of taking it that I took the sleepy kind of cold medication. So I needed to drink a lot of that really nasty coffee today. So tomorrow I'm going to bring a big Tim Hortons. If you guys have questions that you think we should ask the Prime Minister, leave them in the comments. I'm going to check them out. We're still drafting what our questions are going to be. We have some good ones in mind. Sujit, our lawyer, is really exceptional. He's very talented. So I guess that's it. I made a rule that you can only comment on these videos right now if you're subscribed. So thanks to all of you guys who are commenting, because it means you're subscribed to my channel. And if you want to be able to comment, that means you should subscribe to my channel. Okay, I'm going to go to bed now. I'm going to get ready for bed. Long day tomorrow. I'm going to do another live video probably around the same day, the same time tomorrow. So sorry I don't give more advance notice, but these are always available on replay as well. All right. Good night, guys.